Welcome back to Judicial Process. Let's consider Chapter 5, Lawyers and Legal Representation. We will cover these topics in this chapter: legal education, licensing requirements, legal ethics and discipline, bar associations, the work of lawyers, diversity and stratification of the profession, and access to legal services. Before 1870, lawyers were scarce in the colonies. Entry into the profession was opened, but you had to be trained through self-study and often combined with an apprenticeship. The start of the university-based American legal education began at William and Mary in 1779. Legal education connected to philosophy, political economy, and ethics was common. Proprietary law schools, or for-profit law schools, emerged for practitioners in the late 1700s and early 1800s. The modern law school came about at Harvard Law School, and its dean, Christopher Columbus Langdale, changed legal education. Harvard Law introduced the case method, reading appellate court opinions and discussing them in class, and the case method is now the standard form of instruction in law schools. Night law schools were founded as an alternative to university education, and in 1900, there were 32 prestigious law schools founded, the Association of American Law Schools. Law school admissions took off, and in the year 2015, there were nearly 120,000 law students in the United States of America. These law students were admitted based on the law school admission test and undergraduate performance. The Law School Admissions Council develops and administers that test. Applicants use the Law School Data Assembly Service to send their application materials to law schools. In 2015, over 100,000 LSAT tests were given compared to only 37,598 in 1963-64. Women make up about 50% of all enrolled law students, but only 34% of all attorneys. Minorities earn approximately 26% of law degrees. Law school curriculum in the early years was 2 years, whereas today a standard curriculum is 3 years. The curriculum trains students as generalists. It teaches students to think like lawyers. The curriculum has a distinctive feature, and that is the case method. Case books organize appellate court decisions with few references to other disciplines such as history, economics, public policy, etc. The case system also employs the Socratic method, where professors challenge students to explain the logic of their thinking or the court's thinking. No correct way of analyzing opinions is presented in law school. It is the process that counts. Critics of legal education argue the method of instruction is confrontational, which does not suit many learning styles. Some also argue that it's too focused on knowledge needed to pass the bar exam, while others say not enough attention is given to the actual practice of law. There are 204 American Bar Association approved law schools in the year 2014. Most are affiliated with a university, while the rest are freestanding or proprietary law schools. Law schools differ in prestige: elite national law schools, public versus private university law schools, and local versus night law schools. The U.S. News and World Report ranks law schools every year, but not without controversy. The LASAC encourages applicants to find the best law school fit for them. Law school is expensive. 90% of all law students rely on student loans. 2012 surveys showed typical debt for a public law school student was $66,000. For private law school students, it was $126,000. 2/3 of students report that law school debt keeps them from considering public sector jobs. And law school has always been expensive, but the cost is rising faster than lawyer salaries are rising. In order to practice law in a given jurisdiction, one must pass the bar exam. Historically, lawyers were admitted to the bar by courts and judges. Bar associations work to improve the quality of the legal profession, and so most bar exams include basic areas of law, knowledge of state law, and legal ethics. The multi-state bar exam is used in 48 states and offered twice a year. In the year 2010, there were almost 80,000 MBE tests administered, with a pass rate of approximately 68%. New York and California administer the most tests. Other tests include the multi-state professional responsibility test or ethics test and the multi-state essay test. Many students take bar review courses such as Barbary or Themis. Let's spend a moment talking about legal ethics and discipline. Are lawyers dishonest, unscrupulous, and conniving? Increasingly, law schools focus on legal ethics. Bar associations work to improve the public image of lawyers, and state high courts establish the standards of conduct for the legal profession based on the American Bar Association's Model Rules of Professional Conduct. Typically, a state bar association disciplinary committee handles discipline of lawyers. Common complaints of lawyers include misuse of client funds, acceptance of money for services never rendered, and felony convictions. Complaints are filed against lawyers, investigations are performed, and recommendations are made by the State Bar Association Disciplinary Committee. Most complaints are dismissed, while very few result in sanctions. Dissatisfied clients can also file a malpractice lawsuit against lawyers. Let's think about bar associations for a moment. Bar associations were created to try and improve the professional standing of the legal profession. Traditionally, bar associations have been seen as elitist and conservative. 30 states have adopted an integrated bar, requiring all attorneys to join the state bar. The American Bar Association, however, has 600,000 members and is not required, but it attempts to speak for the legal profession anyway. Bar association activities attempt to upgrade the quality of the legal profession while trying to remove dishonest lawyers and promote the public image of the legal profession. Activities aimed at the unauthorized practice of law, such as drafting of contracts, focus on lawyers traditionally having a monopoly over legal services. Advocates argue that legal education is necessary to represent clients, while researchers have found that experience, not legal training, is the best predictor of success in court. Many legal tasks are routine: uncontested divorces, adoptions, name changes, wills, etc. These tasks are being made easier by computer programs and handbooks. What exactly does a lawyer do? Well, many think of lawyers and trials together, but the reality is that most lawyers do not spend their time in court. England draws a formal distinction between solicitors, those attorneys who advise clients but argue only minor cases, and barristers, those litigators who argue cases in major trial courts. Litigating a case presents cases before judges or juries. Trial attorneys must organize a case and the facts presentation to the judge or the jury, and only a small number of attorneys are full-time litigators. Lawyers represent clients with securing licenses, dealing with administrative regulations, and requesting variances. Lawyers also negotiate. Most lawsuits are settled through negotiation. Lawyers work to settle a dispute in the most favorable way for their client. Negotiations in criminal court are frequently referred to as plea bargaining. Lawyers also draft documents. Lawyers spend a great deal of time writing documents. A properly drafted document can help a client avoid a lawsuit in the future. Documents are required at every stage of a lawsuit. Lawyers counsel clients. Lawyers advise clients about the dictates of the law. They are expected to provide sound, dispassionate advice about the law. This role sometimes creates tensions between the lawyer and the client. Lawyers must sometimes give advice that the client would rather not hear. So, for example, the evidence will likely lead to a conviction, or you are not going to be able to get that much money in a settlement. Lawyers also have, the work that lawyers do also includes cause lawyering, which involves the mobilization of the law combined with political calculations. This emerged primarily in the 1960s with civil rights and consumer safety initiatives, and includes both the political left and political right. Today, we may think of religious liberty firms who use the legal system to promote religious liberty. Where exactly do lawyers work? Well, most lawyers, nearly 75% of lawyers, work in private practice. A number of lawyers are even solo practitioners, but that number is declining. Economies of scale make working in a firm or an association of lawyers much more desirable and reasonable. Many lawyers work in business. Many lawyers work as house counsel employed by the business as a salaried employee. Many lawyers work as outside counsel, a lawyer or firm that's hired by the business but not as an employee. Table 5.1 shows you where most lawyers work as of 2010. You can see that most lawyers work in private practice, while some lawyers work in private industry and in the government, the judiciary, in legal aid and public defense, in legal education, and also retired and inactive. Nearly 10% of the nation's lawyers work for the government. So typically we think of government lawyers prosecuting criminals, but many other lawyers are employed by federal, state, and local government. Some lawyers are law clerks that provide legal research and writing for judges. Let's spend a moment thinking about the diversity and stratification of the legal profession. There are many differences among lawyers and law firms. One study found in a Chicago study that lawyers range from general to specific in their practice, with less than 25% considering themselves specialists. Lawyers consistently represent either plaintiffs or defendants, and lawyers tend to represent either large corporations or individuals. That study concluded that lawyers are either part of the corporate sector, representing large corporations, regulatory agencies, or governmental bodies, or personal client sector attorneys, representing individuals. Corporate sector lawyering has been growing faster than the private client sector. Large law firms are often referred to as Wall Street lawyers. The largest law firm as of this publication is Chicago's Baker & McKenzie, with approximately 3,775 lawyers. There's a small number of large law firms, but they have a great deal of influence. They represent mostly corporate clients, and they offer coordinated, highly specialized legal services. Lawyers in these firms are associates and partners. Firm lawyers are sometimes described as finders, those who find new clients, minders, managing the firm, and grinders, those doing the legal research and work. Large law firms participate in bar association leadership and expanded rapidly in the 1980s, but the number of super large law firms has been declining over time. Solo practitioners are individual attorneys who represent one-shotters, individuals who rarely make legal claims, have modest incomes, and focus primarily on criminal, personal injury, divorce, and real estate. Geography is important for determining lawyer employment salaries. Most all new lawyer jobs are in the largest 20 cities. Fastest growth in large states include New York, California, and even Texas. In 2014, the median salary for attorneys is $115,000, with 10% or less making less than $55,000. Well, I've skipped a few slides inadvertently, but let me think for a moment here about legal services. Legal services range from personal services to corporate services, including public defenders who are salaried lawyers who defend on behalf of criminal defendants. Legal services is important for civil representation of the poor. In civil matters, free legal representation is a privilege, not a right. Most such representation is offered by legal clinics, and sometimes concerns contingency fees as well. Opponents charge that contingency fees are unfair to clients because winning lawyers take a large portion of the settlement. Lawyers make too much for their time spent, and the chance of winning big causes reckless behavior by the attorneys. Proponents of such contingency fees counter that lawyers that use a contingency fee do not benefit all that much. They turn away plenty of cases, and it may not cause higher verdicts. Let's think for a moment about advertising in legal clinics. Most advertising for legal clinics is modest. Legal clinics may be run by the community-based organization or a law school, so they don't have the funds to do much advertising. Legal service programs started in 1965 by President Lyndon Johnson to offer civil legal services to the poor. Legal services corporations are private nonprofit corporations established by Congress in 1974. In conclusion, legal representation is very important. Legal education is very rigorous. Lawyers belong to bar associations and attempt to police themselves for ethical violations. The legal profession is diverse, and legal services for indigents in criminal matters is a right, but for civil matters is a privilege.